The African Democratic Congress is not a large party. It does not control a single governorship. It does not have a majority in any state assembly. But it holds something that no amount of money and no amount of political muscle can quickly replicate. A valid INEC registration under the Electoral Act 2022, a registered membership structure across all 36 states and the FCT, and a legal standing that makes it one of only a handful of third parties capable of fielding a credible presidential candidate in 2027 without requiring them to go through PDP or APC. That registration is what this Supreme Court battle is really about. Not a party chairmanship, not an internal election, a registered platform. And the people fighting over it know exactly what it is worth. Nafiu Bala, the current ADC national chairman, or the man who claims to be, whose leadership is at the center of the internal dispute. His faction controls the party secretariat and the administrative structure that interfaces with INEC. Godswill Akpabio, Nigeria's Senate President, a pivotal figure in the ruling APC establishment, who has been publicly and documentedly associated with the Nafiu Bala faction of ADC. The question this video will answer is why a man at the top of the APC federal structure has any documented interest in who leads a small registered third party. The answer to that question is what this video is going to give you. Most channels will give you the ADC leadership crisis as a party gossip story. AfroNewsHQ is going to show you the three-dimensional political operation happening underneath it, who wants control of ADC, what they plan to do with it, and what it means that aggrieved members have now taken this fight to the highest court in Nigeria. Subscribe if you want the architecture behind the headline, because what this story is really about has almost nothing to do with ADC and everything to do with 2027. Section 225 of the 1999 Constitution, as amended, establishes the rights of registered political parties to manage their internal affairs subject to their constitution and INEC's regulatory oversight. It also establishes that INEC has the power to deregister a party that fails to meet membership or operational thresholds, a power that makes INEC's position in internal party disputes not merely advisory, but potentially decisive. The Electoral Act 2022, Section 77 to 84, governs how political parties conduct internal elections, how disputes arising from those elections are resolved, and what role the courts play in adjudicating those disputes. Critically, Section 84 specifically prohibits federal, state, and local government officials, including ministers and their appointees, from voting in or participating in party primaries. The application of this section to ADC's internal leadership crisis is one of the most contested legal questions in the current dispute. The Supreme Court's jurisdiction in party leadership has been established through a series of precedents, most notably in the landmark cases that defined the boundary between internal party affairs and judicial oversight. ADC's aggrieved members are invoking this jurisdiction on the ground that the internal dispute has crossed from a party matter into a constitutional matter, specifically that the manner in which the Nafiu Bala leadership was constituted and consolidated violates the party's own constitution and INEC's regulatory requirements. What the aggrieved members are asking for. First, a judicial declaration on who constitutes the legitimate leadership of ADC under the party's constitution and INEC's registration documents. This is not merely symbolic. INEC interfaces with the party's officially recognized leadership for all regulatory purposes, including candidate nominations. The faction that INEC recognizes is the faction that can field candidates in 2027. Second, an order restraining the Nafiu Bala faction from taking any action, including engaging with INEC, filing candidate nominations, or entering into political agreements on behalf of ADC pending the resolution of the Supreme Court case. Third, implicitly, what the aggrieved members are seeking is time, a Supreme Court order that freezes ADC's formal activities before 2027 prevents the Nafiu Bala-aligned faction from locking in a 2027 political arrangement with a presidential candidate, with a party patron, or with a political establishment that the aggrieved members have not agreed to. ADC's INEC registration has a specific history that makes this legal battle about more than a chairmanship. Understanding that history requires understanding what third-party registration under the Electoral Act 2022 actually costs, not in money, but in time, in documentation, in membership verification, and in the administrative patience that most political ventures in Nigeria do not have. That is why powerful interests want to control ADC rather than build something new. And that is what I will lay out in full in Section 6. Hold it. What the INEC has said and what its silence says. INEC's public communications on the ADC leadership dispute have been characteristically careful, acknowledging the existence of the dispute without formally recognizing either faction as the definitive legal leadership. This studied ambiguity is itself a political statement. An electoral commission that has the power to clarify and chooses not to is an electoral commission that is watching which direction the legal wind blows before committing. The judiciary signals through the lower court rulings that preceded the Supreme Court filing have been mixed. At least one lower court granted an interim injunction that was subsequently challenged. The fact that the aggrieved members bypassed the Court of Appeal and went directly to the Supreme Court suggests they either received a signal that lower court outcomes would continue to be contested or that they have specific constitutional grounds that require the highest court's jurisdiction from the outset. The critical deadline the viewer must understand: INEC's timetable for 2027 candidate registration will open within the next 12 to 18 months. Any party whose leadership is under active legal dispute at that point risks having its candidate's eligibility challenged at the tribunal level, which is precisely the outcome the Nafiu Bala faction's opponents are engineering by escalating to the Supreme Court now rather than later. Who Akpabio is. Godswill Akpabio is the president of the Nigerian Senate, the highest legislative office in the country. He was the APC's governorship candidate in Akwa Ibom State before his federal career, served as Minister of Niger Delta Affairs under Buhari, and is one of the most politically experienced and strategically sophisticated figures in the Tinubu administration's orbit. He is also a South-South politician from Akwa Ibom State, adjacent to Rivers State, whose regional political interests overlap significantly with the dynamics of the ADC crisis, because ADC has documented membership strength in the South-South states, including Akwa Ibom, Rivers, and Delta. The documented connection between Akpabio and the Nafiu Bala faction of ADC has appeared in multiple Nigerian newspaper reports, in public statements by the aggrieved ADC faction, and in the legal filings associated with the dispute. AfroNewsHQ is not making an allegation. We are analyzing a documented political relationship and asking the only question that analytical rigor requires: what is the strategic logic? Why controlling ADC serves the APC's 2027 interests? A registered third party that is controlled by the ruling establishment is a third party that can be used to split opposition votes in strategic states without the APC having to do it directly. This is not a novel political technique. It has been used in Nigerian politics before, in multiple states, in both governorship and presidential elections. A friendly third-party candidate in Akwa Ibom, Rivers, or Delta, who takes 8 to 12% of the opposition vote in those states, changes the outcome of those states' contests without the APC needing to win them. A registered third party under establishment-aligned leadership is also a party whose presidential candidacy, if any, can be managed. A 2027 ADC presidential candidate who is vetted by and acceptable to the ruling establishment is not a threat to Tinubu's coalition. An ADC presidential candidacy that goes to a genuine opposition figure, one not aligned with the establishment, is a different calculation entirely. The South-South dimension. Akpabio's regional interest in ADC's leadership is not only national. His home state of Akwa Ibom is a state where a credible third-party candidacy in the 2027 governorship race or in Senate and House contests could determine whether APC gains ground in a region where it has historically struggled. ADC's registered membership in Akwa Ibom makes it a potentially useful instrument for that kind of targeted electoral engineering. Here is the historical pattern that makes the Akpabio ADC connection legible rather than surprising. In 2019, the Social Democratic Party was used in specific states as a vote-splitting instrument that benefited the APC in governorship contests. In 2023, multiple smaller registered parties fielded presidential candidates whose campaigns were documented to have received funding from sources connected to the APC establishment, not to win, but to reduce the opposition's vote share in targeted states. This is a documented practice in Nigerian electoral politics. It leaves no clean paper trail, but it follows a recognizable geometry, and the geometry of Akpabio's involvement in ADC's leadership follows it precisely. What this means for ADC's aggrieved members. The aggrieved members are not simply fighting for a chairmanship they believe was stolen from them. They are fighting to prevent their registered party platform from being converted into an instrument of the political establishment they joined ADC specifically to oppose. That is a different kind of political grievance from a standard internal party dispute, and it explains why they have been willing to invest the resources and the legal urgency required to go directly to the Supreme Court. It also explains why their case has attracted attention beyond the immediate parties to the dispute. Every genuine opposition political actor in Nigeria, every Labour Party strategist, every PDP figure calculating 2027 scenarios, every civil society organization monitoring third-party political space has an interest in the outcome of this Supreme Court filing. INEC has historically recognized the faction of a disputed party that holds the physical secretariat, the official seal, and the administrative documents registered with the Commission, regardless of which faction has the better internal legal argument. This is an administrative convenience that has repeatedly produced outcomes that advantage whichever faction controls the party's physical and bureaucratic infrastructure at the moment of INEC's inquiry. In the ADC dispute, the Nafiu Bala faction controls the secretariat. This is the documented starting position. An INEC that follows its historical administrative pattern would recognize the Nafiu Bala faction as the default legitimate leadership, pending a court order to the contrary. The aggrieved ADC members' Supreme Court filing is designed precisely to produce that court order before INEC's administrative convenience can be exercised. INEC's recent record in the off-cycle elections of 2024 and 2025 has generated significant criticism from opposition parties, election monitoring organizations, and international observers regarding the Commission's responsiveness to political pressure from the federal government. That record is relevant context for how the aggrieved ADC members are calculating the risk of relying on INEC to resolve this dispute administratively rather than judicially. The Supreme Court's record in party leadership disputes. The Supreme Court has, in its landmark rulings on internal party matters, established a doctrine of minimal judicial interference in party affairs, holding that courts should intervene only when party conduct violates the Constitution or applicable legislation, not merely when party internal procedures produce outcomes that some members disagree with. This doctrine creates a high bar for the aggrieved ADC members. Their Supreme Court application must demonstrate not just that the Nafiu Bala leadership was constituted in a manner they disagree with, but that it was constituted in a manner that violates ADC's own constitution or applicable national law. The specific grounds on which they have filed and whether those grounds clear this doctrinal threshold will determine whether the Supreme Court grants their application or dismisses it. The timing of the Supreme Court's resolution, whether it rules before or after INEC's 2027 candidate registration window opens, may matter as much as the substance of the ruling. a court that rules in favor of the aggrieved members but does so after INEC has already processed all 2027 candidate nominations under the Nafiu Bala leadership, will have produced a legal victory that is practically hollow. The most relevant judicial precedent for the ADC Supreme Court filing is the series of rulings around the Plateau State governorship dispute of 2023, in which the Supreme Court ultimately ruled in a manner that overturned lower court decisions and restored a candidate whose eligibility had been challenged on procedural grounds. That ruling was significant not for its legal reasoning alone, but for its demonstration that the Supreme Court, when presented with a matter where institutional legitimacy rather than personal ambition is at stake, is capable of interventions that the lower courts were unwilling to make. The ADC aggrieved members are betting that the Supreme Court will read their case through a similar institutional legitimacy lens. Whether that bet is correct is the most important legal question in Nigerian politics right now, outside of a sitting government case. If the institutional picture I just drew is landing the way I think it is, drop a comment right now. Tell me, do you think the Supreme Court will intervene before INEC's 2027 timetable kicks in? Because the next section is where I show you exactly what date this crisis was engineered around and why that date tells you everything about who planned it and what they wanted. The ADC internal crisis escalated from a party administration dispute into a documented institutional confrontation involving INEC correspondence, court filings, and the public emergence of the Akpabio connection in the period between July and September 2024. This is the period immediately following INEC's publication of its revised timetable for 2027 electoral activities, which set out the approximate windows for party registration reviews, candidate nomination periods, and the formal opening of the 2027 election cycle. That alignment is not coincidental. A political crisis inside a registered third party that erupts within weeks of INEC publishing its 2027 electoral timetable is a crisis that was triggered by the timetable. The publication of that timetable made ADC's registered platform suddenly, concretely, and urgently valuable, not as a party-building exercise, but as a 2027 candidate delivery mechanism. The people who moved to consolidate control of ADC in that window moved because they understood that INEC's timetable had created a closing window. Once INEC's candidate nomination processes open, the faction with registered recognition controls the party's 2027 role. The ADC aggrieved members also understand this. The Supreme Court filing is their attempt to prevent the window from closing on the wrong faction. Who benefits from the timing? Follow the incentive. The Nafiu Bala faction benefits from the crisis happening now rather than later because resolving it in their favor before INEC's timetable advances locks in their control of ADC's 2027 candidacy process. Speed favors the faction in possession of the secretariat. The Akpabio-aligned federal establishment interests benefit from the crisis happening now because it allows them to influence ADC's 2027 positioning before any alternative presidential candidacy, specifically not aligned with the APC establishment, can be formalized through ADC's platform. The aggrieved members also understand this. The Supreme Court filing is their attempt to prevent the window from closing on the wrong faction. The 2027 significance: if the Supreme Court rules in favor of the aggrieved members and installs a leadership that is genuinely independent of the federal establishment, ADC becomes a live platform for an opposition presidential candidacy that does not require PDP's primary process or Labour Party's existing candidate relationships. That outcome, an independent, legally clean ADC platform available for a 2027 presidential candidacy, is the outcome the Akpabio-aligned interests are most motivated to prevent. What ADC's registration actually represents. To register a political party with INEC under the Electoral Act 2022, an organization must demonstrate a minimum membership of 300,000 Nigerians spread across at least 24 states and the FTC, a national secretariat, a functioning state-level party structure, an audited financial statement, and a party constitution that meets INEC's regulatory requirements. This process takes a minimum of 18 months under optimal conditions. Under realistic Nigerian conditions, it takes longer. ADC completed this process. Its registration is documented, its membership threshold is verified, and its legal standing as a registered party is not in dispute. Only its leadership is. This means that whoever controls ADC's recognized leadership controls a political platform that would take a new entrant at minimum 2 years and tens of millions of naira to replicate from scratch. In the 18 months remaining before INEC's 2027 candidate nomination window opens, no new party can complete the registration process in time to field a presidential candidate. ADC and the handful of other registered third parties that have cleared the threshold are, for the purposes of 2027, an irreplaceable resource. That irreplaceability is the source of every conflict this video has documented. The 3 possible outcomes. Outcome 1. Supreme Court rules for the aggrieved members, installs independent leadership. AVC becomes a genuinely independent third-party platform. Its 2027 candidacy is available to whoever the reconstituted leadership chooses to field. The opposition gains a legally clean alternative to PDP and Labour Party. The federal establishment loses a potential vote-splitting instrument in the South-South. This is the outcome with the most significant national electoral consequences. Outcome 2. Supreme Court dismisses or delays, Nafiu Bala faction retains INEC recognition. ADC's 2027 candidacy is controlled by a leadership with documented connections to the federal political establishment. The party's presidential candidate, if it fields one, is a candidate the establishment has either vetted or can manage. ADC becomes a political instrument rather than a political party. Its 2027 role is to fragment, not to win. Outcome 3. Supreme Court rules, but the ruling arrives after INEC's nomination window. ADC's 2027 candidates are already filed under the Nafiu Bala leadership. The legal victory for the aggrieved members is real, but practically hollow. The 2027 election proceeds with ADC's platform locked under establishment-aligned control. This is the outcome the timing of the Supreme Court filing was specifically designed to prevent. And whether it can be prevented depends entirely on how quickly the Supreme Court moves. The most honest assessment. The aggrieved ADC members went to the Supreme Court because every other avenue had been exhausted or compromised. That decision itself is a statement about the state of Nigerian political institutions, about what it means when a group of citizens who followed their party's rules, paid their dues, and built a registered structure find that that structure they built can be captured by people with more connections to federal power than they have. This is not just ADC's problem. It is a stress test of whether Nigerian democracy has institutions capable of protecting political space from institutional capture. We started with a question. Why does Nigeria's Senate President have any business inside the internal affairs of a small registered opposition party? We have now answered that question with documented analysis, the registration value, the 2027 platform logic, the vote-splitting geometry, and the INEC timetable that triggered the crisis. The ADC Supreme Court filing is not a party gossip story. It is a legal battle over who controls a registered platform in a democratic system where registered platforms are scarce, expensive to build, and, in the 12 months before 2027, more valuable than at any other point in the Nigerian electoral calendar. Whoever wins at the Supreme Court wins more than a chairmanship. They win the right to decide what ADC does in 2027. And what ADC does in 2027 may determine whether the opposition has a genuine third platform in the presidential race, or whether that platform has been quietly converted into a tool designed to ensure it never gets one. Now you understand that the ADC crisis is not a small party's internal quarrel. It is a battle over the architecture of the 2027 opposition space, fought in court, in INEC's corridors, and in the offices of people whose names are attached to this story in ways that Nigerian mainstream media has described, but not fully analyzed. AfroNewsHQ gave you the full analysis. Nigeria deserves better than headline coverage of a story this important. I will see you in the next one.